Welcome to We Dissent, the podcast with secular women attorneys discussing religious liberty issues in our federal and state courts and our work to keep religion and government separate. I'm Rebecca Markert with the Freedom from Religion Foundation.
And I'm Alison Gill with American Atheists.
And I'm Liz Cavell, also with the Freedom from Religion Foundation.
In today's episode, we are going to do a state of state-church separation in the United States. Regular listeners know that we've been covering the most recent cases at the Supreme Court, which have bulldozed the wall of separation. But the court has actually been chipping away at the wall for a number of years. And today we are excited to welcome another guest, Professor Caroline Corbin, to discuss how we got here and what comes next with regard to the Establishment Clause. We're also very excited because she is an academic. Most of our guests have been advocates for state-church separation or other social justice issues. So we are really excited to have a more academic conversation with Professor Corbin today. I will give you a brief introduction to Professor Corbin. She is a professor of law at the University of Miami. She teaches all the con law courses, Con Law 1, Con Law 2, the First Amendment, the Religion Clauses, the Free Speech Clause, feminism and the First Amendment, and advanced topics in reproductive rights. Her scholarship focuses on the First Amendment's speech and religion clauses, particularly their intersection with equality issues. She's litigated civil rights cases as a pro bono fellow at Sullivan and Cromwell, and as an attorney at the ACLU Reproductive Freedom Project. She also clerked for Judge Blaine Michael of the United States Court of Appeals for the Fourth Circuit. She graduated with a BA from Harvard University and earned her law degree at Columbia Law School. So welcome, Professor Corbin.
Thank you. I'm very excited to be here.
I was really excited for you to be on our show because we've been working together for a number of years. And I don't know if you recall, but the first time I met you was actually at the Secular Coalition for America's Lobby Day. I think it was like 10 years ago. It was a long time ago. But we had exchanged business cards, and after that, you were really good about sending us law review articles about the issues that we were working on. That was so helpful. We ended up sending them to all of our attorneys to help keep them abreast of the scholarship in that area. But I was also really excited about it because, first of all, it was scholarship from a secular viewpoint. A lot of times when you go on to law review journals, you get a lot of articles about religious liberty issues from religious schools. So I was excited, one, because you were writing from a secular perspective, but two, you're a woman constitutional law professor, and that is also just incredible and rare. And so I was very excited to make your acquaintance and keep this relationship going for a long time.
It's funny because I know a lot of people come to the religion clauses because of their faith. I actually ended up here because of my interest in reproductive rights. I actually started my career, as you mentioned, at the ACLU Reproductive Freedom Project, and you can't work on reproductive rights in this country without crashing into religion. And so that's the path, one of the paths that led me to working on religion clauses from a more secular point of view.
I think it's interesting because I think that's true for more and more areas. It's certainly true for LGBTQ issues. It's one of the reasons I'm so interested in this area. But I mean, so many others. End of life, even employment issues these days impact religion so much, or are impacted by religion law so much.
Let's get into our topic for today. The first question that we have for you, Professor Corbin, is about the importance and the significance of the Establishment Clause. We have been working in this space for a very long time, and we understand why it's so important for Americans to understand and to work hard to protect. But maybe you can tell us a little bit about the history of the Establishment Clause and why all Americans should care about state-church separation?
Absolutely. From my point of view, I think the Establishment Clause is crucial both for the religious liberty of religious minorities and for the equality of religious minorities. So it plays a really important role in both liberty and equality. Starting with liberty, and this is the liberty of people who belong to minority faiths. So, for example, if you had a teacher who led the class in Christian prayers at the beginning of each school day, that might coerce someone to participate in prayers of someone else's faith contrary to their own religious beliefs and practices. And that is why the Establishment Clause bars it. It's one key purpose of the Establishment Clause is actually to promote religion, but to promote the religious liberty not of the majority, but of the minority. So that's one important role it plays. The other is just protecting equality based on religious belief. And by preventing the government from favoring one religion over other religions, or even some religions over other religion, it prevents the government from creating a religious hierarchy where people who do not belong to the religious majority, and I include both people who belong to minority religions and those who have no religion at all, it prevents those people from becoming second-class citizens. So the Establishment Clause plays a crucial role in protecting both religious liberty and equality in the country. And so I think it is a vastly underappreciated clause in the U.S. Constitution.
Obviously, the courts, the Supreme Court at least, has declared that it does not value the Establishment Clause as you just described it, right? Like those values of neutrality and true religious liberty with a focus on protecting the minority from majoritarian power. So given that, a lot of the project of our organizations right now is trying to really convince the American public that these values are still essential to American democracy. I think the Supreme Court has gotten away with a lot in this area because people don't see the Establishment Clause as something important to democracy, to their own power, to equality in the way that you're describing it. How do you communicate that? Or have you found a way to kind of communicate the urgency of the First Amendment and the Establishment Clause to regular people?
I don't know if I've been successful. I mean, I think there are maybe two slightly different audiences. For those who really value religious liberty and find it to be essential to their own lives, it's really worth emphasizing that part of the purpose of the Establishment Clause is to promote religious liberty. I think that's an aspect that has too often gotten lost. And I think it's really important. And I think emphasizing that it's both clauses that protect religious liberty, and you need both of them. It's not going to work if you only protect free exercise clause rights. And obviously, especially if you only protect the free exercise clause rights of conservative Christians. But to really say that the Establishment Clause and the Free Exercise Clause work together to protect everybody's religious liberty. So I think that's one sort of approach to communication that may often be overlooked when people talk about the Establishment Clause is how important it is actually to religious liberty. So that's one part. And then as for equality, I mean, who doesn't think equality is important? Well, again, I suppose there are some who don't. I think one of the greatest disservices the Supreme Court has done to the Establishment Clause is to reduce the harm of the violations of the Establishment Clause to nothing more than offense, right? So the court is always saying how, I don't even know why this person has standing, like, I don't even know why they have the right to bring a case. They're just offended, right? And I think you need to respond to that continued claim that this is nothing but people being offended. It's like, it's not about people being offended. It's about people not being treated as an equal in our community because of their religious beliefs. So how do you argue that persuasively? I don't know. People understand racial hierarchies, which is why I use the term religious hierarchy, because people understand that when you do something that impinges on the dignity of a person of color, that is more than just offense. It conveys a message that they're not equal, they're not as worthy, they're not a full member of the community. And so I think another narrative to really emphasize is this is so much about making sure that everybody is an equal citizen, regardless of what they believe in vis-a-vis religion.
Can I just add, I think that it's hard to get people to care a lot about abstract constitutional principles, I think. I think people are going to care about the application. And so it's our job, I think, to take, when we see these outrageous cases which offend us, and to hold them up and show people the religious aspect and why that's working. And also to counteract Christian nationalism, which basically says religious hierarchies are okay as long as Christians are on top, because that's the goal of the United States. So we have to counteract that narrative, because if people are okay with religious hierarchies just because they're winning, that's not acceptable, right?
That's so true, Alison. And I was laughing a little bit, Professor Corbin, because when we were emailing back and forth about the outline, you sent a message because it's not in the outline. Do we want to talk about Christian nationalism at all? And I was literally laughing in my office because I'm like, how do we talk about what's happened to the Establishment Clause in our courts without talking about Christian nationalism, right? And so, Alison, obviously that's so right. There's a whole nother project going on in the courts. It's not just reasoned academic debates about applying constitutional law principles. It's a project to put into power Christian supremacy through law. That's a huge part of how we try to tackle communicating about these issues, is like really ringing the alarm about how much of what the court is doing is really about making second-class citizens out of everybody who is not a Christian.
So I want to just jump in and ask about atheism, because we're talking a lot about how these religion clauses protect religious liberty of everyone, and you are free to believe what you want. But let's bring it back to the freedom to not believe. And where does that fit in with the religion clauses? Because I think when we're talking about offense and you're offended by something, I feel like the atheists always get sort of like the short shrift here, because, for a lot of Americans who are believers, they really do think like you shouldn't be offended, because if you don't believe it, it shouldn't matter to you. Just look the other way. Can you talk a little bit about what the religion clauses say about somebody who doesn't believe?
Yeah, so again, I think the example that I started with about the teacher who starts the day with a Christian prayer, and students are inevitably going to feel pressure to participate, even if it's against their own religious convictions. And that religious conviction can be, well, I'm Jewish and I don't believe in Jesus Christ and he's not my Lord and Savior, or I'm an atheist and I don't believe in any of this, and it is equally intruding on my own moral conscience to have to recite this. So again, the protection is for everybody who's not a member of the majority faith. And that goes equally for all the discussions about how it makes them second-class citizens. So the protection, it reaches everyone who's not a member of the favored religion to have a clause in the Constitution say the government cannot favor one religion over others. The government cannot force you to participate in a religious exercise, not your own. The government will not be funding the practice of one religion. All these things are the types of things the Establishment Clause has been understood to prohibit.
And what has the Supreme Court said about non-believers?
Depends which one you're talking about.
This one.
Well, they have said the religion clauses encompass both the right to believe and not to believe.
Absolutely. It was supposed to protect, it was supposed to make whatever you believe not relevant as far as the government was concerned. And whether you believed in, multiple deities or you believed in nothing at all, the religion clause, at least the Establishment Clause, was meant to reach you. The Free Exercise Clause, not so much. So the Free Exercise Clause is really about those who have some kind of faith. Although, again, where the line is not always clear, right? Humanism might be in, but pure atheism may not be in terms of free exercise. But for establishment, it's to protect people based on what they believe, regardless of what that belief is. And so it definitely encompasses atheists, and Supreme Court has repeatedly said that. This court has not said it otherwise. It just doesn't care anymore about religious minorities, or at least it seems to have little interest in protecting people based on their religious belief in the same way that previous Supreme Courts have.
It's really the saddest thing about what has happened to the Establishment Clause. It's been slowly happening as the court's gotten more conservative over the past couple of decades, but obviously has been majorly accelerated by the current court in its super majority. But the saddest thing is that the cases that we all have kind of built a lot of our work on, they go back 40, 50, 60 years, right? There are these big, broad Supreme Court cases and early cases interpreting the Establishment Clause as it was applied to state and local governments and school districts. And the language is that strong neutrality language of the Establishment Clause prohibits the government playing favorites amongst religion against religion or religion in general against non-religion, right? And it's just so sad to see how much this court has just completely eroded that principle to meaninglessness, because that's kind of the best part, I think, about the Establishment Clause is that it does that leveling of a playing field for all of us so that nobody can be second-class citizens based on your religion.
Well, building on that, then, I thought it might make sense to talk about some of the general principles that have been in place to understand the way the Establishment Clause has traditionally functioned, and then what the court has done to sort of subvert it, and what the new rules are, such as they are. Rules are in quotes. So, for example, I was reading this great paper recently by Professors Lupu and Tuttle called The Remains of the Establishment Clause, where he sort of lays out is that the idea of religion is distinct. Religion is set aside as special by the First Amendment, and that the Establishment Clause and the Free Exercise Clause work together to establish that religion has a special place in our law and it's treated differently than other issues. And so, and the way the Establishment Clause and the Free Exercise Clause function around that religion can be treated differently. And so that has all sorts of applications. And to the counterpoint, what the modern court has done is to say, well, religion must be treated almost like in the most beneficial way possible, either equally to secular issues or it must be given special privileges when it requests. But it seems to be whatever most favors religion is how it should be treated. But it's no longer distinct. It's no longer like you can segregate it out and say religion is treated differently.
I would have a friendly amendment to that, which is religion is special when it comes to free exercise and granting religion special accommodations. But religion is the same when it comes to limits on religion and the Establishment Clause and funding. So basically, religion gets to have its cake and eat it too, right? So religion is distinct and special when it comes to giving it special accommodations and sort of providing it with exceptions from general laws that nobody else gets under free exercise. But it's absolutely the same when it comes to funding, for example. You now have to fund religion in exactly the same way you would fund a religion counterpart. So it is distinct or the same, depending, as what Alison said, depending on what best favors religion. So it's not that they've completely eliminated the fact that it's distinct. It's just that they choose when it's distinct. And the choice to be distinct is one that always favors religion. And the choice to say it's not distinct always favors religion. So really, it's a regime where religion wins.
That seems to be the court's motto these days, doesn't it?
Yes. Well, again, most of the recent cases we've seen go before the court have been cases brought by conservative Christians. Whether progressive attempts to gain special privileges and accommodations and exemptions from law, whether those progressive attempts at free exercise claims will be equally as successful is another story. So, for example, you have all these Jewish plaintiffs bringing free exercise claims, challenging abortion laws. We'll see if they also can take advantage of the really expansive protections that this Supreme Court has created. I mean, under the existing doctrine, they should win, but again, we'll see.
So when looking at general principles under the Establishment Clause, for decades, the tests revolved around things like, what is the purpose of the government action? What is the effect? Is there too much entanglement between government and religion? And separately, does it appear to the casual observer that there's an endorsement by the government of religion? Those are some of the tests that have traditionally guided our litigation in this area for 50 years or more. Where are we today? Is any of that still true?
No. So what Alison is talking about doctrinally, there were certain tests that the Supreme Court used, particularly in cases involving things like religious displays, like the Ten Commandments or Latin crosses, or in religious exercises like the government leading prayers. And so there were certain rules, there were certain tests the court had created in order to decide whether they violated the Establishment Clause. So, for example, one of the queries was, does this government action, does it have a primarily secular purpose, or is the primary purpose religious? Because if the primary purpose is religious, or to promote religion, that would violate the Establishment Clause. Or the question would be, well, would people who saw this religious display, would they think the government was endorsing religion? Or would it sort of inevitably conclude, yeah, the government is really preferring one religion over another? Because again, the government was not supposed to favor one religion over others. As we talked about at the very beginning, that kind of neutrality vis-a-vis religions was essential to religious liberty and equality based on religion. And so that was one of the limits that the court placed on what the government could do vis-a-vis religion. Those tests are gone. And instead, what have replaced them, thanks to the Roberts Court, is a presumption that long-standing religious practices, like prayers before opening sessions of the government, long-standing religious practices or long-standing religious displays. So like if there's been a 10 Commandments in front of the courthouse for 100 years, they're going to assume those are presumptively constitutional. That's the new rule. How they justify the new rule is a little trickier to explain. But the new sort of just the rule in the law is if it's been around long enough, they're going to presume it is constitutional unless shown otherwise. And while that's written in a way that does not seem to favor one particular religion, in reality, of course, it's going to favor Christianity, because what other group had the power to have prayers beforehand or put up a monument of its religion? They've basically just created a presumption that longstanding Christian monuments and practices are perfectly fine, because the touchstone for Establishment Clause is no longer whether there's a secular purpose, or no longer whether it has the effect of creating second-class citizens. The touchstone is now history and tradition. If there's enough of a history and enough of a tradition, it's just going to be peachy keen as far as this court is concerned. They have shifted the doctrine in a way that almost guarantees that the government can favor Christianity.
And even outside of the displays and religious practices matters, they're still using history to tradition test. And I'm sure we're going to get into more detail there. But there was a Fourth Circuit panel that basically said how the Establishment Clause was supposed to work in their vision based on the Supreme Court's precedents. The panel added in this is the Firewalker Fields v. Lee case, the panel added that the plaintiff has the burden of proving a set of facts that would have historically been understood as an establishment of religion. So basically, something is only a violative of the Establishment Clause if the plaintiff can prove it is a establishment of religion, which is good luck to do that.
Yeah. Caroline, you're an academic and a lawyer, but how problematic it is to say, okay, history is the touchstone in these cases. And so lawyers and judges, put on your historian hats and make your best case. And we see how that shakes out, right? This is not like some true searching examination of what the historical record supports. This is what we call law office history. It's just who can do a convincing argument about how history supports their favored result. And the judges do this all the time in these cases. How does the Roberts Court purport to divine what history supports as judges? And it's not like a layperson might think, oh, well, you just get historians to like do honest assessments of the historical record. And we do have experts that get hired in some of these cases, and probably we'll see that more. But if you read these opinions and the history that is cited, what is a good way that this could ever work, even if it were a valid framework for analyzing what the Establishment Clause means?
And I'll just tack on there, too, what is longstanding? I mean, How long does it have to be historic before it's presumptively constitutional? Like 20 years, 30 years? Or are we looking at 100 years?
5 years?
Right.
Like it's all relative.
It's a nightmare test. It's a nightmare test for so many different reasons. One of which you already mentioned is that lawyers are not trained historians, right? So the very first problem is that courts do not have the institutional competence to conduct this kind of inquiry. And you can't have every case turn into a deep dive into history from 200 years ago, 100 years ago. All right, so problem number one. Problem number two is the assumption that this history can be uncovered. There are many reasons why it may not be uncovered. One of which is there was never a consensus on the question, because just as people today have very different viewpoints on what the Establishment Clause does or does not allow, so did people 50 years ago and 100 years ago and at the founding. There is not a single understanding of the Establishment Clause. And the third problem of trying to look to history and why you may not find an answer is because there is no answer, because history was not faced with this particular question. We are a very different country today than we were 50 years ago. And there have been incredible changes in our society. And so the very specific question before the court might not have been a specific question that existed in history. And so, do you allow funding of charter schools? Like, there were no charter schools. Like, how could we possibly figure that out? And then, never mind the fact that judges are notorious for cherry picking history or even in good faith. I mean, how many times have we seen the courts take this understanding of the Second Amendment? Judges, the dissent and the majority both looked to history, both wrote dozens and dozens and dozens of pages on what the history should lead them to conclude, and came to completely different answers. And this doesn't even get into the question of how broadly do you frame the inquiry. So I'm sorry, this is my reproductive rights background coming into play, but let me do an analogy with Dobbs, where, again, that also they looked to history. And the question they asked was, is the right to abortion deeply rooted in our nation's history and tradition? And even setting aside their completely dishonest excavation of the history on abortion, that was by no means the only way to phrase the inquiry. They could have instead asked, is the right to make medical decisions about your own body deeply rooted in our nation's history and tradition? So even assuming there is some answer in the mists of history that we can uncover, the answer might vary depending on how we frame the question. And I haven't even gotten into the normative problems with relying on history. Why in the world would you rely on history to determine our rights today? We know that history is filled with sexism and racism and homophobia and anti-Semitism and anti-Catholicism. History should not be what determines our rights today. So that was a bit of a rant. I could go on longer, but I think I've given you, I hope, at least a taste of some of the problems of trying to rely on history to determine constitutional rights.
What do you think the reason is for this reliance on history?
I think there are at least two. One, because they can get whatever answer they want, because you can find in history evidence to support whatever conclusion you want vis-a-vis the Establishment Clause because of this and that, so many different disagreements. And second, because history is sort of conservative and Christian. Interpret the Establishment Clause vis-a-vis history, you're going to have a lot of decisions that favor conservative values and conservative Christianity. And for this court, that is just fine.
Yeah, when you said the normative bias to history, well, it's that's so true, because it really is just the whole point of the historical framework paradigm is it's the Christian nationalism project, right? It's the project of making sure that enshrined in our Establishment Clause jurisprudence, if you look to the founding, Christian supremacy was normal, and therefore it's a feedback loop. It's a circular argument. Therefore, that's what the Establishment Clause was meant to be tolerant of. Therefore, it's a Christian nation.
I think the historical approach also allows the court to ignore the consequences of imposing this paradigm. They don't get to have to grapple with the consequences of imposing this historical paradigms, whether it be repro, whether it be separation of church and state, onto the modern pluralistic society, and it also allows them to ignore precedent, right? They don't have to grapple with why Engel v. Vitale was decided a certain way, right? If they can just say, well, historically, this is not how it was done, or something along those lines. So you can see they sort of get around the precedent instead of grappling with it. They ignore it.
Yeah, I think that's a really good point, Alison. I actually also think it allows them to get to decisions without offering a principled explanation.
Absolutely.
So, for example, in Town of Greece versus Galloway, which is a case which involved a town that had prayers before its town meetings. And just about all the prayers turned out to be Christian. And the Supreme Court, and again, that would seem a pretty straightforward violation of the long-standing Establishment Clause prohibition against favoring some religions over others. But rather than engaging with that principle, what the Supreme Court said was, well, at the very founding of our country, people prayed during legislative sessions, and some of those prayers were Christian. And therefore, if they didn't think it was unconstitutional, then neither should we, without actually explaining why that might have been acceptable. And the reason it might have been acceptable is because at the time, the particular prayers to God that they had included everybody, right? Everybody believed in God. And so everybody there was pretty much Christian. And so the prayer was inclusive at the time. Whereas today, the exact same prayer that the founders might have thought was just fine, that exact same prayer would not be inclusive because we are a nation, thankfully, of dozens and hundreds of different kinds of religion. And it's impossible to come up with a prayer that's inclusive, especially because a large chunk of the country is not religious at all. So rather than engaging with this principle and trying to explain how this principle plays out today in a religious prayer case, they're just like, oh, they did it then, we can do it today. We're not even going to think about what the principles of the Establishment Clause might or might not be.
But you hit it right on the head, which is that's the point. It's not some accident of the analysis, right? It's the whole purpose of doing it that way is to achieve exactly that end, which is to say it was very inclusive then, and I liked it better then because I'm in that in-group. So I'm going to say that same behavior in government, even though the effects are completely different now, it's still okay because you can't get away from the fact that none of this is happening in good faith on the part of the Roberts Court. It's all a project to harken back to what they view as a Christian nationalist past.
And the one other thing about history, this is what I forgot to mention, is sometimes they rely on it and sometimes they don't. One thing that is stunning is in their funding cases, right? You don't see a lot of discussion of the original understanding or the history of the Establishment Clause because there's no long discussion of James Madison's Memorial and Remonstrance, which is the original polemic on why the government should not fund religion and churches. Like, that's not in their analysis. Again, even though they have this very, very much this turn toward history, they're not even consistent in whether they rely on it or not. If they did rely on it, the answers would not always be the ones they seem to be coming to with regard to funding and the Establishment Clause.
And that's what we've talked about a lot on this podcast, is that this court is very outcome determinative. They want a specific outcome, and history gets them there. Like you said at the outset, they are able to cherry pick the history they want to get a particular decision. We've said time and again, they're a very activist court, and I don't use that term lightly because I never believed that the Supreme Court was that way until the Roberts Court. So I think that is the biggest reason they're putting this analysis out there, is because they want a particular outcome, and that outcome is to privilege Christianity over all other faiths and a particular version of Christianity.
Absolutely, right? And we see that, again, that sometimes they don't even use history if the history is a little problematic for their conclusion.
Well, to get into how this court has used the Free Exercise Clause and really elevating that clause above Establishment Clause concerns instead of analyzing them in conjunction the way that prior courts have, that is where the court has really been able to effectuate this heads we win, tails you lose kind of analysis, because like you said, Professor Corbin, how the history doesn't favor, for example, their outcome in the funding space where they're trying to access government funding for religious purposes, religious organizations or schools or whatever it may be. So those cases are very forward on the free exercise argument, right? They're not trying to dip into the neutrality principles embedded in the Establishment Clause. Basically, the argument is our free exercise rights entitle us to this funding on a neutral basis. And the Establishment Clause is no impediment to that because we've neutered the Establishment Clause beyond all recognition. And so they've just manipulated the whole First Amendment, both religion clauses, to work towards this outcome.
The changes in the rules when it comes to funding religion have really given me whiplash. They have so fundamentally shifted from when I first started, which wasn't even that long ago, right? Once upon a time, boys and girls, once upon a time, the main religion clause question when the government was directing funds to religious organizations was whether or not it violated the Establishment Clause. And so the whole question was always, can the government direct this money to a religious church or school without it violating the Establishment Clause? And there was a whole edifice about when it was okay and when it was not. So if it was used for secular purposes and direct funding, it might be okay. And if it was indirect funding, meaning if you gave a voucher to a parent who then decided to give it to a religious school, that was okay because any religiosity was attributed to the parent and not to the government, right? And so those were the questions when it came to government funding. But now the question with government funding seems to be a failure to give money to a religious school is now considered a free exercise violation. And the court has consistently held that the government's decision not to include religious organizations in a funding scheme violates the free exercise clause. It's discrimination against religion, as though the Establishment Clause did not exist, right? Again, once upon a time, the government was allowed to further Establishment Clause values, even if it wasn't required to, right? Even if the Establishment Clause did not require them not to include religious organizations, they could still do so voluntarily because it was part of our history, actually, part of our understanding of having a secular government, that we didn't give money to religious organizations. That's not allowed anymore. Now it's labeled discrimination against religion. Again, as though there were no Establishment Clause, but there is. Not only is there an Establishment Clause, there's a long and storied history of not giving money to religious schools. And that has just dropped out of the current court's analyses. I mean, they have actually described Establishment Clause values as policy preferences in their funding decisions. The change is just startling and disappointing.
I mean, they're poised to go even further than that in the next few years, right? I mean, the question now is going to be, can they impose any restrictions along with that funding on religious organizations? They certainly can for secular organizations, but we'll see if they can for religious organizations in the long run. We're already starting to see that maybe they can't. I mean, look at Fulton, right? And look at Carson in Maine. So I guess that's going to be the next question. Like, you know, do they get both guaranteed money and also no restrictions tied to the money besides those that they voluntarily agree with? Is that where we are? We just have, well, isn't that the definition of a theocracy? I don't know. I mean, I'm
right. Well, Alison, what you're referencing the Carson versus Makin case, which we did a full episode on this podcast last year about, and then a follow-up episode when the decision came down last summer. The postscript on the Carson case is those same schools, conservative Christian schools, that have now been told you have a right to public funding, that's not enough. They're back in court because they want that funding free of restrictions such as anti-discrimination and other restrictions that we put on our public money because we used to have a right to make those decisions about how we spend our taxpayer dollars.
Also, we have an equal protection clause. I think one of the startling developments is the way the court is thinking about discrimination. So anytime religion does not get exactly what it wants, it is suffering from discrimination. At the same time, it seems completely blind to the actual discrimination that is being perpetuated by some of these organizations that are getting funding, or they seem really cavalier about what it means to be denied services because you are a same-sex couple, or to be denied health care because you're a woman. They're very nonchalant about the discrimination that others suffer, while they find discrimination against religious groups that are not actually being discriminated against.
This sort of reminds me of this case in the Fifth Circuit, the American Airlines case, which was a vaccination case. I believe it's American Airlines, might be United Airlines, which was a vaccination case brought under Title VII about an employment issue. And basically, instead of applying standard law, the court there, the Fifth Circuit, went out of its way to create this special whole new area of how you apply employment law under the Civil Rights Act of 1964. I mean, it had been applied for a standard way for 50 years, and they created this whole new way of applying it when dealing with religion. And I think that finding religious discrimination and finding ways to remedy religious discrimination is how we're seeing a lot of these conservative courts view the law.
You're hitting on something, Alison, that's, I think, really important. It's this whole expansive religious preference in the law in all of these different cases that sort of feeds into the erosion of Establishment Clause principles, just the expansion of religious exemptions in all these different areas of law, the new sort of preoccupation with hostility towards religion in all of the analysis under both the Free Exercise and the Establishment Clause.
I wonder if what's happening is, I think sort of looking more broadly, I think that a lot of conservative Christians have been privileged in the law, right? They're very used to having the law reflect their beliefs and their values.
It's also just so frustrating to me because they're losing their privilege, but practically speaking, what have they lost? Like, they're still able to live their lives according to their religious beliefs and carry out those practices. There's nothing really that's hurting them. How have their lives changed because minority faiths and people of no faith are also reaching an equal status to them?
Absolutely, right? The fact that two women can get married does not prevent them from marrying someone of the opposite sex. Right. But again, the world is no longer a perfect reflection of their values, and I guess that's hard. I mean, those of us who are minorities, like, we're used to it. We're used to navigating a world that is not designed for us. Right? If you're Jewish, you don't get Rosh Hashanah off. It's not a national holiday. Like, Passover Seder, the schools don't close. Right? Whereas that's new. It's new for a lot of Christians to not have everything sort of designed, like everything fall into place perfectly for them. It's just so new, and they're just not used to it, and just having a little bit of a tantrum.
I love that example because of the ridiculous war on Christmas narrative that comes around every year. I mean, it's a perfect reflection of like their grievance, right? Reflected in law.
Right? There's no, like, it's a national holiday.
But then it begs the question, like, what more do you want? It's not enough to have the whole society ordered around your particular religious viewpoint. it's never enough. Like, that's the thing, because it's a backlash from the culture war. It's not just the loss of legal privilege, like Rebecca's saying. It's that the culture has changed, and now my views seem gross to a lot of people, and that makes me feel bad.
They've lost their privilege. Like the society is no longer a perfect reflection of their needs and their values.
And they want those people not to exist. I mean, that's
Right.
it.
Right. That is it. And so much of this, Alison, I think you're hitting on, is that so much of the conservative Christian takeover of the courts and their use of the courts is aimed, or is a backlash to so much of the sex-based cultural changes, like the changes in the culture around reproductive freedom, changes in the culture big time around LGBTQ rights and acceptance. And that's why you see so much of this. You know, I'm on about this all the time, Alison and Rebecca, on this podcast, which is like, this court is so obsessed in their hostility framing with giving permission, in their opinions, to conservative Christians to hold their bigoted beliefs against gay people. It's like they have to say every chance they get that good and honorable and decent people have views about gay people on all sides of the issue.
We're gearing up for this year's Supreme Court session, but the major case from last year was, of course, Kennedy v. Bremerton. So that was, I think, the most significant case when it came to the Establishment Clause in the past decade or more, I think. So it'd be interesting to hear your perspective on the significant changes it made in the law. Our amicus brief that we submitted was focused on the dangers of treating religious speech differently than other types of speech, right? So giving higher deference to religious speech, considering it more free speechy than other types of speech. So I'd love to hear your thoughts on that issue as well and how it could impact the law.
Okay, so I'll start by saying that historically, the Supreme Court has been especially mindful of the Establishment Clause in the school context. Because, again, one of the general prohibitions of the Establishment Clause is that the government cannot force people to participate in religious exercises. And there are different ways you might coerce someone into participating. One is you punish them if they don't. Another is just you bring to bear a lot of pressure on people. So in the school context, the court recognized that even if a student wouldn't be suspended from school if they didn't participate in the prayer at the beginning of the school day, there's a lot of social pressure to join in, right? There's a lot of peer pressure if all the other kids are doing it. There's also the pressure from your teacher who's going to be grading you and disciplining you. And so there was this acknowledgement that children in particular might find themselves doing things that they really didn't want to do at school. And so even as Establishment Clause protections crumbled in the outside world, they still remained at school. So the question is whether Bremerton changed that. And in that case, you had a coach, a football coach, who wanted to say a prayer immediately after football games in the middle of the public school football field. And there were allegations that a lot of students felt like they had to join in, and that he asked players from other schools to join in. And it was like, it was sort of bringing to bear exactly that kind of pressure that the Supreme Court had recognized in the past was especially problematic under the Establishment Clause. And so, again, what you would have thought would be a primarily Establishment Clause claim was actually a free exercise claim brought by the coach, because the school said to him, listen, if you need to pray after football games, that's fine, but please don't do it in the middle of the football field immediately after when the students are there. Can you please at least wait until the students leave? Or if you need to do it immediately after, can you do it on the side of the field, right? And so he won. He won. The Supreme Court said that his free exercise rights were violated because prayer is obviously crucial and he didn't get to pray as he needed to. And so the question is there no establishment clause in the school anymore because of this decision? Here's the thing about this decision. The facts that I have explained to you were not the facts as recited by the Supreme Court. The Supreme Court created a very different case, a case not necessarily based on the facts. What they claimed was that he only wanted to pray privately and that nobody ever joined in. So there was a whole series of events where he prayed. They only took a couple of them. It involved free speech as well. And so let me just explain, in free speech, there is a major difference between, or an establishment, maybe I should say this, an establishment clause. The establishment clause limits the government. It doesn't limit private speakers. So one of the main questions was, when the coach was praying, was he praying as a representative of the school so that his prayers are attributed to the school and trigger the establishment clause? Or were they purely private speech, in which case they would be protected by the free speech clause? Now, not as extensively as they might be if he weren't a public school employee, but it was a sort of different question. So one of the preliminary questions, one of the first issues the court had to decide is, how should we think about this coach's speech? Is this something that's really attributed to the school, or is this really just a private person trying to have a quiet, private prayer? And they said it was the latter, which was not what the facts were, right? Right? You know how in like books of fiction, like any resemblance to real characters is purely coincidental? That a bit like the facts as recited by the Supreme Court. This is a work of fiction, our description of the actual issue before the court. But if we take them at their word, I don't know if they've completely dismantled the establishment clause in the school context, because as far as they were concerned, this was not about a teacher praying with the class as part of the school day at the beginning of the school day. This was just one guy trying to like pray to God after the game during a private moment. It was purely private. It had nothing to do with the establishment clause. Strictly speaking, they may not have totally destroyed establishment clause protections in the school. Of course, the very fact that they manipulated the facts in such a way that they could reach a conclusion that it was okay for the coach to pray is problematic. And certainly lower courts are using the case to allow more things than had previously been allowed. But I'm going to make a pitch, and this may just be a desperate Hail Mary. I want to hope that this is not the complete end of any establishment clause protection in the public schools because of the way the Supreme Court described the case, at least as a matter of doctrine. Now, in reality, it's a little different, but they have not come out and said schools may now pray, schools may now sponsor prayers, right? The schools may now post 10 commandments. Schools may now read passages from the Bible. That is not what this case holds. And so all of that edifice of protection that the line of Supreme Court cases have established is still there. That's my perhaps wishful thinking on the Establishment Clause in schools.
I think that lawyers have a tendency to hang on to these shaky reeds of distinction, right? That that in reality don't play out that way. Because think about this, if you're a school district and you have a choice between disciplining a teacher that decides to start every day with prayer versus the Establishment Clause rights of your students, and you have to go to court based on this situation today, are more school districts going to are just going to defer and say, well, this isn't worth the legal risk to us?
Yes, I think, again, I was saying, so I was talking about doctrinally what's happened and the real world what happened. But
yeah,
because the doctrine is intact, it means that when the student sues and it goes before a court can still uphold Establishment Clause protections in schools because the other cases are still good.
Mm-hmm.
And so it's important to remember, most cases don't get to the Supreme Court. Most cases are resolved at the district court and court of appeals level. The doctrine is still there in the school context in the way it simply is not outside the school context. I absolutely think that both schools and courts will misunderstand the holding, and those that are keen to have prayer back in school will distort it to their advantage. But those courts that care about religious liberty of all and equality of all still have precedent that they can refer to reach what I think are the decisions in line with how we understand the Establishment Clause.
I think it's significant that the way that the court chose to speak on this issue was through this case that was brought in this posture of a disciplined teacher suing the school in an employment dispute. And, oh, look, we're just touching on the Establishment Clause issue tangentially. It's ancillary to the dispute, but Lemon was long ago abandoned. We're just going to put that in there. And introduce this historical practices and understandings is what courts and school districts should be thinking of going forward. But this case is not about the Establishment Clause. It's about Coach Kennedy and, his employment dispute with the district and how he was treated and what protections his speech deserved. It's devious, right? Like, it's a way of addressing the issue sideways without saying prayer is okay in public schools, the Establishment Clause means nothing. But it sort of nibbles around the edges of that and signals to the lower courts, when faced with these situations, we are going to prioritize the rights of this actor.
Yes.
Yeah,
clearly, the rights of the conservative Christian coach who wanted to pray were more important than the rights of students who might have felt compelled to participate in the prayers, lest they be penalized for not doing so by a coach who clearly had very strong feelings about Christianity. Their lack of empathy for the religious minorities is in keeping with the complete lack of empathy they displayed in the cases outside the school context. I could just as easily construct an argument that all is lost as well, because there's certainly plenty in the language to lament.
Caroline, you've talked a bit about how one of the major components or parts of the Establishment Clause is to prevent coercion. And here, the court they just sort of ignored the idea that there could have been indirect coercion, or the indirect coercion is something that matters, right? They discussed it a little bit, but they mostly didn't grapple with it. And by that, I mean, do you want to add something? Sorry.
I was going to say, they didn't grapple with it because their fantasy case did not involve any children praying. So
Exactly.
as far as they were concerned, they didn't have to address the issue because all that was at stake was this poor man who was simply trying to pray after football games by himself.
But that is the difference between sort of the Establishment Clause in a way and the Free Exercise Clause is direct versus indirect coercion in some ways, right? If we're concerned about indirect coercion, then we have to care a little bit more about the Establishment Clause. If we're concerned about them strapping students down to chairs and sort of directly, forcefully proselytizing them coercively, then the free exercise clause might cover that, and maybe the establishment clause is entirely repetitive, and what I mean. It's not needed to provide that protection. So I guess I'm wondering, given, I don't know if you agree with that framework, but
I don't know. I think in the situation where a teacher said to a student, if you do not join the class in prayer, I'm failing you. I actually think that's a establishment clause claim more than a free exercise claim. I tend to think of a free exercise claim is the teacher won't let the student practice their faith, whereas the school forcing them to do something against their faith is establishment.
Well,
so
it's both, right?
I mean, again, you could always bring multiple claims. Like these things involve multiple things, but that's how I primarily think about free exercise as the government is prohibiting you from observing the precepts of your faith, whereas the establishment clause is sort of forcing you to participate in their own religious exercises.
There's also a free speech component there as well.
Oh my God, yes. There's lots of intersection. I mean, the Kennedy case also involved sort of free speech issues about government employee. I mean, there was a lot of other stuff going on.
I think you're right, Alison. They didn't grapple too much with indirect coercion. And like Professor Corbin said, they kind of pretended that the facts didn't really warrant a discussion of coercion or indirect or direct. But I do think what is so disheartening is that you can see between the lines there is that the way that they talk about the facts and how they would or would not show indirect coercion just shows, and I don't think it's benign. I mean, I think it's deliberate misunderstanding of the concept. This circular thing of, well, nobody came forward to say anything or absented themselves from anything, so therefore there clearly wasn't any indirect coercion. It's like, no, that's the whole thing of indirect coercion. Everyone participates because they have to. I'm not hopeful that they would give a true hearing to a factual presentation of an indirectly coercive public school case, because the way that they sort of write off their need to analyze coercion in this case is sort of just a complete obliviousness to how indirect coercion would present itself in a public school context case.
I absolutely think they're moving towards narrowing what counts as coercion. So either they're going to limit it to actual legal coercion, where there has to be a threat of punishment and simply eliminate social pressure entirely, or they're going to narrow the social pressure, as you described, as you have to actually prove that you were pressured into participating, which is an evidentiary showing they will no longer presume that something is coercive. You will have to prove it, and it's not clear how you would prove it. And so even though it might exist in theory, it's not going to exist so much in practice. They haven't done it yet.
Right. That's not the law now, but that is such a shameful thing. And if the court does eventually go there, because what we should be so proud of is the early interpretations of the Establishment Clause in the public school context and the ways in which courts were willing to recognize how inherently coercive the public school environment is and how government power is really at its apex in our public schools. For all the reasons, right? Public school is compulsory, or school is compulsory. Students, kids are vulnerable and so impressionable. And just anyone who's been to school understands how socially coercive the environment is and how coercive the relationships are in terms of the power dynamics between students.
So when I teach the school prayer cases, the first thing I do in class is I ask everybody to stand and to repeat after me. And I have my students say the Regent's Prayer. And most of them do. And I think having that experience of being coerced into praying, even when they may not want to have, helps them understand social pressure. And because again, it's so easy to make the argument that, well, if people know they don't have to do it, then they're not going to do it. And the point I try to make with that exercise is you're not in grade school. You're not in high school. You're not in college. You're in law school. You're a grown-up now. Not only are you a grown-up, but you just read all these Supreme Court decisions saying how coercive these are and that you don't have to participate. And yet, despite being in grad school as an adult, fully informed about the law, you still felt the pressure to participate. I don't know how to replicate that more widely so that people understood how much pressure there is on people to participate in these things.
I love that.
But I think your point is like school is so coercive for precisely the reasons you said. You got to be there. There's a huge power differential between the student and the teacher. Never mind all the other kids, especially if you're like in the Bible Belt.
I want to recap our discussion here because I think it's really important for our listeners and everybody to understand what our legal landscape actually looks like now and what the threats and concerns are. So I thought I would go and sort of do a rapid fire with you, Professor Corbin, put you in the hot seat. I will give you these typical area of complaints that our organizations have received, and I want you to answer whether you think these practices are constitutional or not, and whether our organizations would be successful in any sort of challenges and lawsuits on these areas. So we're going to start first with legislative prayer. This is the issue where city councils, county governments, and even state legislatures and Congress pray before their sessions. Is a practice like that constitutional?
If in theory it is open to different types of prayer and they're not singling out a particular religion, they're not intentionally excluding a particular religion, absolutely constitutional. We saw in Town of Greece versus Galloway that they can be mostly Christian and it's still okay because the reason they were mostly Christian is most of their volunteers happen to be Christian.
So when is it unconstitutional?
It would be unconstitutional if they said, we are having prayers before our town meetings and we are only inviting Christian denominations to come join us.
But they can't exclude atheists, though, right? Because actually there was a case on that a few years ago.
That is a good question. I would think that would not be okay, but I don't know if that would. That's one of the questions of the scope of protection for atheists. I think, again, if you are singling out someone because of their religious belief, then I think it's an Establishment Clause problem. If they were cleverer, what they would say, they would do what Town of Greece did, is like, we're opening this to any congregation in the town. That would be okay.
So then we'll move over to displays because traditionally our organizations have done a lot with displays, and a lot of our members to our organizations get really upset about these types of displays. So the first one is going to be nativity scenes. Always happen in December. There is a nativity scene depicting the birth of Jesus on a courthouse lawn or in a public park, something like that. Is that constitutional or unconstitutional now?
Again, it might depend on the context. There is still precedent that a government-sponsored nativity scene with only a nativity scene and nothing else might raise Establishment Clause problems. On the other hand, so for the lower courts, they would be bound by that. On the other hand, you might have a town saying, we've been doing this for 100 years and no one's ever complained before, and it now falls into the category of a long-standing practice and therefore is perfectly constitutional. So I could see that going either way, depending on who's making the decision.
Right. And I also think that the decision or the opinion that you're referencing there, Allegheny, also rested heavily on Lemon, which is now discarded. So I wonder if lower courts would feel bound by the Allegheny decision.
Absolutely, that's true. Right. Although, again, the way to respond is it was not a practice at the founding, and therefore it is not something that it is deeply embedded in our nation's history and traditions. And to the extent that it has become part of our history and tradition, it has only done so in the case where it was either a public forum open to all kinds of religious displays, or the government made clear that it was celebrating something other than the actual birth of Christ, that it was celebrating the holiday season. So there are certainly ways to respond to it, even if you are constrained by making a history and tradition argument.
So the next display, crosses.
Used to be kind of non-controversial to say that a cross on public property represented unconstitutional government religion.
Okay, so here, if it is new, then I think it might still be unconstitutional because, again, this presumption of constitutionality, it has to be a long-standing history and tradition. And I really think they meant like things that have been around for a while that are now part of the culture of the place. Nativity scenes, they could kind of make it sort of part of the culture of Christmas, right? So if it's a new cross, it's a problem. So the Supreme Court upheld a giant Latin cross in the middle of a highway and said it was fine because the cross represented those who sacrificed for World War I. So the hook there was they were able to characterize it as something other than the symbol of Jesus Christ. Not persuasively, but they at least had this argument, right? And they constructed this whole history that when people see the cross, they think World War I. Although I do not know any Jewish person who sees a cross of World War I that's setting aside that argument. So again, is it possible to construct that kind of argument around the Latin cross? Maybe. But if it's just like a town wants to erect a new giant cross, I think they might still have some hurdles, even under the Supreme Court's "we love Christian symbols" decisions.
I mean, Alito also said that going after these crosses is actually might be targeting religious symbols unfairly, and that might be a violation of targeting of religion that's improper. So
there's that
anyway.
Again,
hostility.
Yeah.
Any enforcement of the Establishment Clause has become hostility to religion and a potential free exercise violation. Although it might be hard to argue that, I don't think the government can argue that they have a free exercise right. But yes, Alison, there's definitely the immediate way that the court changes any attempt to enforce Establishment Clause values into persecution of religion.
Yeah.
All right, next hypo.
10 Commandments.
Oh.
So we have two different displays that we are dealing with here. So one is just 10 Commandment displays on public property. And then the second is 10 Commandment displays, usually in the form of posters, but sometimes also monuments on public school property.
Okay. So I think the 10 Commandments, I think the court will be, again, controlling. There are cases that say, the 10 Commandments are inherently religious and therefore it could be problematic if just placed on their own. However, if we're going up to the Supreme Court, I think the Supreme Court will be able to construct a history around the 10 Commandments as being foundational to our nation's culture and history and who we are as a people. And so I think that they are not going to strike down 10 Commandments display, even if it's all on its own, outside of a museum, on government property, in schools.
They could just talk about the educational benefits, right? I mean,
thou shalt not cover thy neighbor's wife. I don't know. I think it might fall under one of their more recent bans on. They have so many bans in public schools. I would think that the Bible would get banned under some of those, if not, even if not the Ten Commandments. That's a harder call. Again, that really depends on whether they care anymore about protecting students. Again, I mean, the Ten Commandments are not the basis of our law. Most of the commandments have nothing to do with law. They have to do with having one God, observing the Sabbath, honoring your parents, not coveting. These are not legal things. So I don't know what they're going to do with the 10. And I think that's definitely going to reach them, because there are so many states now trying to impose Christianity in the schools. I would hope that they would strike that down. Right. I don't know why I'm not as confident that they're going to uphold it, and it may just be wishful thinking. But there is very clear precedent on this, and you are right, of course, that they can ignore precedent because it was based on tests that they have now eliminated. But I don't know if there's a history and tradition of 10 commandments in the public schools, right? And of course, there's also the really obvious problem that any version of the 10 commandments is going to be favoring one religion or some religions over others, right? There is not a single 10 commandments. There's the Jewish 10 commandments, there's the Catholic 10 commandments, there's Protestant 10 commandments. They're all different. And so by virtue of choosing one of them, they're going to be favoring one religion over another. But that, again, that may be something that they happily gloss over. And so I'm bumbling over the ones in school because every fiber of my being says that violates the Establishment Clause. And yet I don't know what the court would do with that.
Yeah, I think you're right. And we do see a lot of states entertaining legislation that would put these up in schools. I'm thinking particularly of efforts currently in Texas to put the 10 Commandments up in the form of posters in public schools. I do think that that's being set up as a case to overturn Stone versus Graham, which was the case from, 1980, that said that display was unconstitutional. So that's something that I think we're going to see. So the last two that I have, we kind of talked about at length, but funding to religious organizations, including schools, and then school prayer.
Well, again, the funding of the public schools depends on the context, right? If you are only funding religious schools, I think that would still violate the Establishment Clause. Now, I'm assuming you're imagining some program that's open to secular and private schools alike, and it just so happens that all the private schools are religious. Would that violate the Establishment Clause? That would not. Though I'm still not sure if you can use direct funds for religious purposes, right? All the funding cases they've decided so far, they have still been able to claim either that the funding was used for secular purposes. So even if the money went directly to a church, it was used for its playground, which was something secular. Or if the money went to a religious school, it went there indirectly because of a voucher program or a tax rebate program or something like that. So again, I think the case we're going to see is it's going to be direct funding to a religious school that's using the money for religious purposes.
It'll be the charter school cases, right? The charter school case are ginning up in Oklahoma.
And that will really be the final, there is no limit on funding if you make it available to both religious and secular. We're not quite there yet, right? The courts is still trying to say it's discrimination if you won't give the money just because they're religious in character, right? They haven't said you can give the money to religious school even if they use it for a religious purpose. They actually kind of claim that that's still something, that's still the the bricks are there, right? They're crumbling. The cement has eroded. But that part of the wall is just the foundation is really eaten away. That part of the wall is still there. You cannot give direct taxpayer money to a religious church or school that uses it for a religious purpose. That'll go, I suspect, but it's not gone yet.
I mean, isn't that kind of what's happening in Carson, or do you view that as indirect in some way?
I still think that's indirect because the money didn't, because it was a very complicated structure.
But it did get rid of the use versus status distinction. Yes. And like that's a key sort of component of what we're talking about here.
Yeah. But as I said, they haven't, so I think they will do it. I'm just saying they haven't yet done it. So if you're in the lower courts, you can still make that argument.
Got it.
So what do you think is left of the Establishment Clause?
Yeah, right. Okay.
And where's the future of litigation? Where do you see these cases coming?
Like if you're looking for a good case to take, what does that look like?
There are just cases that gives the Supreme Court opportunities to further chip away at the Establishment Clause. I'm sorry.
Fine.
So in terms of prayers, you cannot intentionally discriminate against other religions. You can't say we're going to have legislative prayers, but only Christians are welcome to give the opening prayer. You still can't do that. I don't think you can erect a giant Latin cross in the courtrooms. There's no history or tradition of giant Latin crosses in the courtroom. I don't know if they can construct a story around that being something that's deeply rooted in our history and tradition. Some new crosses without stories might still violate the Establishment Clause. I think you can't, like, if you're going to have money end up at religious places, you can't give it only to religious places, right? So if you're going to have you can't have a program to buy sacred text. You can't have the sacred text fund, and that's only used to buy sacred religious books. Right? Because that, again, I think in the funding context, you have to make it equally available to religious and secular. Although, again, whether you can directly fund religious activities, I don't know. And I think in terms of coercion, like, you still can't force someone to participate in prayer on pain of legal punishment, though the government never says you must participate, otherwise we're going to exclude you. So I don't think those cases ever existed in the first place. So maybe that's really not as helpful. So there's probably other things left. Maybe? What did I leave off my list? Like, so again, I still think you cannot intentionally and obviously and on the face favor one or some religions over others as sort of a bigger principle. I mean, there are so many ways to get around that so that you still could favor Christianity, but you can't do it on its face. You can't do that on the face of things. And funding, maybe you still can't only fund religion and directly fund religious education and exercise. I don't know. What do you all think of my list?
It's pretty short.
It's pretty narrow. It's not just short, but it's narrow. Like, those are conditions that are very specific and easy to get around. And I would also say that it doesn't provide much leverage for us as advocates or other litigators in the field to sort of have leverage to rebuild the wall of church-state separation. It doesn't provide us a context to say, okay, how do we advance rights? How do we separate church and state? The answer is we rely on other constitutional protections, or we go into a different field of law, right? There's not just...
Right.
I think what you want are cases that won't go to the Supreme Court. Because again, I think my answers are very different for the lower courts than they are for the Supreme Court. because I think that a lot of the lower courts, even though the Supreme Court has eliminated its longstanding tests, I think the lower courts will still follow precedent. Or I think that's their inclination, is in the first instance, they're not going to be, now, of course, there are some exceptions, but I think most are not going to be trailblazers in eviscerating the Establishment Clause. And so I think you have more room to maneuver with cases that don't get to the Supreme Court, because then you can bring your challenges to religious displays and your crosses and the creches that are all by the nativity scenes with nothing else around them, and the things that are going on in the schools. I think there's a lot of precedent and principles that can be argued in favor of them violating the Establishment Clause. The funding, like the history, like there's history and tradition about not funding, right? So you need to get the religious scholars who really look at this and have them make, like, I think you want to make arguments about precedent, about principle, and then you get them to make the historical argument and to say all these three strands inevitably point towards finding this unconstitutional. You can manipulate history too, is what I'm saying. So maybe the one other limit, and this is the one, and this I haven't, is like, are these places discriminating, and how does this intersect with the Equal Protection Clause? I think I have to, that's, state action doctrine is a disaster and a mess and not one I'm familiar with, but there has to be at some point at which equal protection comes into play with the government giving money to organizations that discriminate, right? And so that's a potential limit on funding like that. Although again, the Supreme Court might bulldoze over that as well.
While we're stuck in this defensive posture on the Establishment Clause, it's hard to effectively litigate offensively to expand Establishment Clause protections when you're litigating a policy of avoidance of the Supreme Court, right? Like, you can only do so much there. But I think what we're all sort of thinking through collectively is, how do we use these other tools?
I think you need to take a look at our history and revisit a history. Because the states have in their state constitution prohibitions on funding religion. And the Supreme Court tries to get around that by saying it's motivated by anti-Catholic animus. Well, first of all, if they're relying on history and tradition, it doesn't matter what motivated them, right? Because you can say Christian prayers were motivated by anti-Semitism. Like, animus matters or it doesn't.
Right. It doesn't matter for crosses, right? Apparently, if you have 40 feet tall crosses, but... Right?
but second, I think there is... I think we have not really mined our history enough in terms, there's a lot of history in support of separation of church and state. And I think that's the history that's got to be presented in all these cases. And starting with Memorial and Remonstrance, which talks about degrading from the ranks of equal citizenship all those who don't belong to the majority faith. There's a rich, rich tradition of secular government. And so if they're going to look to history, so can we, because I said the history doesn't always point in one direction, and often it might point in a more secular approach to these things. Fight history with history.
And the other answer is court reform.
Always.
Well, I think that's it for today's episode. We want to thank you, Professor Corbin, so much for joining us. This was a great discussion. I'm sure our listeners are going to learn a lot. So thank you very much.
Thank you so much for having me. As soon as I saw this podcast, I crossed my fingers hoping you would have me on as guest. And so I'm delighted to be here. Hope this is the first of many podcasts.
Wonderful. Well, thank you very much. So that's it. And if you don't already, please be sure to check us out on Twitter and on Facebook and online at we-dissent.org. We'd love to hear how you're enjoying our show, so please remember to leave us a review. Thanks for tuning in. I'm Rebecca Markert.
I'm Alison Gill.
And I'm Liz Cavell. Thanks for listening.
We Dissent is a joint production of the Freedom from Religion Foundation and American Atheists. It is hosted by attorneys Liz Cavell, Alison Gill, and me, Rebecca Markert. Other production support comes from Greta Martins. Audio engineering provided by Audio for the Arts based in Madison, Wisconsin. Thanks for listening.